Well, moving now from the property law side of things and building to something that's going to be on a lot of people's minds as well, particularly coming up to end of financial year now, people are going to be wanting to jump ship, maybe get a new gig. Are non-compete contracts or clauses in contracts enforceable for employees and employers?
Yeah, absolutely. Please don't tell me it's the end of the financial year yet. I have a lot more work to do. But you're right. I mean, ultimately, particularly in the current market, and particularly the market that was created by the COVID sort of employment, working from home and all these things, we're dealing with it as employers all the time. There is constantly going to be shifts and moves in the professional services market, particularly. Are a restraint of trade clauses enforceable? As an employee, very rarely is the court going to actually uphold a restraint of trade if you are just a PAYG employee. In order for that to be the case, there needs to be a range of factors the court finds in favour of the restraint applying. And those factors include effectively whether or not the business is genuinely in need of the protection and whether or not it's appropriate in our structured legal system for that sort of anti-competitive conduct. So we have the Australian Competition and Consumer Commission, the ACCC, and Australia's market is defined as a free and open market, and that's ACCC's job to make sure that that's the case. But it goes to the policy principles behind that, which is that it's the public interest that people are allowed to work for their living, and they're allowed to do so in a free and open marketplace. So basically, they're not enforceable unless the court thinks it's appropriate to enforce them. Usually in employer-employee situations, someone has to have been paid a premium upon their exit for there to be some sort of a binding restraint, because of the reality that unless that's the case, they're entitled to go and earn a living the next day at a different job. That can change once you get into more senior positions, and restraints of trade tend to start really being relevant as you get to senior management and to a higher pay bracket, particularly in respect of client services where clients might follow that individual. So it doesn't necessarily have to be that though. We actually have an example of a recent case where there was a person working in the beauty industry, and they were working in a country town in Victoria, and the court actually found that the restraint was binding on this individual within 5 kilometres of the premises of their employer. They had 1,900 clients that they'd serviced over 5 years in their beauty services business that ultimately the court banned them from dealing with for a period of time if they were operating within 5 kilometres of the original premises at which they were employed. So it's not that there's just no way of ever making it binding. It's very much about the type of business you're in, what you're being paid to be in that business, and whether or not it works out in the business's favour. The position that we are finding ourselves in a lot of the time is that professional services have moved to alternative protections. Information protection, that is confidential information and confidential clauses, but also liquidated damages clauses. And now in Australia, liquidated damages clauses are not banned and are not voided by the law and the public interest. That is, if you move and you take clients with you, you'll pay us for those clients and the value that you take from our business. That is something that you need to be really careful of if you're an employee in the professional services space. And it's something that, as an employer advisor, we're telling a lot of our employers that they should be adding to their to their employment agreements if they have a person who's taking up a senior role and so have that client rapport, that's an important asset of their business that requires protection, and that's another way to do it. So are they enforceable? Usually not. It's not in the public interest unless the court thinks that it is, and it's a bit of a case-by-case scenario, and it's literally what the courts say. It's a case-by-case, we'll consider every case on its merits. What we ultimately find is it's just a cost-benefit analysis. The employee, can I afford to be sued? The employer, how much is it going to cost us to not sue? And therefore, they're in a lot of employment contracts as a motivational proposition. I'm trying to motivate the employee not to compete against us in our local market. by the risk of them being found to be at fault or to be guilty of breaching their restraints. And that's ultimately where it comes down to, is a leverage mechanism a lot of the time in our employment contracts that we're drafting. But they do get enforced, as that beauty therapist found out, which was a huge change for that person. Like, most people would have expected that wouldn't have gone through. But small country town, word of mouth is very important for that business. Therefore, the court did find that it was an appropriate thing to restrain her from operating within a very close radius of that business for 12 months from leaving the business. So, it's a bit of a yes/no answer, frankly. But that's the way they work, and it is up to the court, ultimately.
No, makes sense. Something that we're putting in a lot of our contracts at the moment, just to make sure that there is the option for these types of clauses to be binding, are ladder clauses.
Yep.
But we're finding a lot of clients don't understand those. What is a ladder clause?
Yeah, ladder clause, or also known as a cascading clause. So they're clauses that effectively, there's multiple options within the restraint. So you might find that it says that you are restrained within the restraint period, and you're restrained within the restraint area. And then you go to the definitions, and restraint period says 5 different periods. It might start at 2 months, it might go out to 5 years, and then you might have restraint area is 5 kilometres out to the whole of Australia, and different categories. And then you'll have something like a statement in that clause that says each individual restraint period and restraint area is combined with the other to create its own clause. And effectively, the way you have to read that clause is as if there's, if you've got 5 times by 5, you've got 25 different versions of how that clause could play out. And so effectively, you've got to read the contract as if there's 25 different restraint areas and restraint periods that work together and build that ladder. And the reason we're doing that is because the law says that the court will read down the contract sufficiently to make the restraint the most appropriate that the court thinks is available to the situation. So it might feel that in that instance I was telling you about before, that case, the restraint was also for 25 kilometres and it was also for 4 years, for example. But the court found that no, that wasn't really reasonable. And so what these restraint ladder or cascading clauses create is the ability for the court to find the perfect middle ground that it feels is appropriate in the circumstances. Does it always work? No. Does every time you've got that in a contract guarantee you an enforceable restraint clause? No. Does it increase the likelihood of the restraint clause being effective? Absolutely. And ultimately that comes down to the contract review principles associated with, well, if I'm going to read a contract down to an appropriate level of restrictiveness, if I don't have those options, I can't do that as a judge. So a judge can only read the contract with what it has in it. They can't add things to the contract, so it's about giving the judge options. That's effectively what they do. So hopefully that helps people understand it. If you don't understand it, that's okay. Come and talk to us. We can explain it. Doesn't take that long. And each individual case is case by case. So you may well have ladder clauses that make a lot of sense, or you may well have ladder clauses that are ridiculous, and we can explain whether that's the case and what your risk factors are. Before you sign it, ideally, if you've already signed it and you want to move, before you leave, we've done all that sort of work and we can help with that.